All right, let's talk about how the Supreme Court selects their cases. Like I mentioned before, there are thousands and thousands and thousands of cases that appeal to the Supreme Court every single year. Remember, Supreme Court has two kinds of jurisdiction. They have what's called original jurisdiction, where a case starts, and they have appellate jurisdiction, where they hear cases on appeal. They hear about 100 cases a year, and there are like about 8,000 that are presented to them to consider. They pick about, like I said, about 100. So of all the cases that come to them originally, like this is the first and last stop, about 4 or 5 generally out of that 100, isn't it? They originate in the Supreme Court, and they're usually disputes between the states. About 95+% come to them on some sort of appeal. What happens is the court will issue what's called a writ of certiorari, meaning they give a notice to the lower court, one of the appeals courts, to say, send that file up, we'd like to look at it, and then they kind of decide if that's something they want to run with. Like we mentioned before, it's not enough just to be an interesting case. There has to be some sort of legal error that they think needs to be corrected. They operate on what's called the rule of 4. So of all the cases that they see that they issued the writ of certiorari for, most of them don't ever see the actual court. They're put on a discussion list, the ones that the justices feel are interesting. They are on a discussion list, and at their meetings, the secret meetings that everybody knows about, they discuss which ones they like. The rule of 4, quite simply, is if 4 of the 9 justices are like, we want to hear this one, they put it on the docket and they listen to the case. Okay. There's lots of reasons to pick a case. Okay. There's kind of 4 criteria that they really use. First of all, a case that makes a difference. So they don't want to do something just to settle a point of law. So, for example, a long time ago, we had something called the Equal Rights Amendment that was proposed as an amendment to be part of the U.S. Constitution. It was passed by Congress and started out like wildfire. All these states started approving it, and then it bogged down, and they couldn't get the 3/4 of states to actually approve it. The time ran out on the proposal, so the amendment went away. Idaho decided, they voted yes, that they wanted to ratify the ERA. And then, because there's a rule that once you say yes, you can't change that to no, they wanted to challenge that in the Supreme Court. They wanted to change their yes to a no. Now, the Supreme Court said, we're not going to hear that case. The ERA was never ratified. It's dead. What does it matter at this point? Like, it doesn't make any difference. Like, if you voted yes and you lost, or if you voted no and you won. I mean, the end result is there was no amendment that was ratified, so who cares if you were on the winning side or losing side? You got what you wanted in the end. So it didn't make a difference. So the Supreme Court refuses to hear things like that. They will not offer what's called an advisory opinion. So if basically somebody says like, hey, this law looks like it's a piece of garbage, we'd like you to rule on it to see what you think. They won't do that. Somebody has to have suffered real harm, meaning I have to have fallen victim to that rule in order to go before you as to challenge that. The case Griswold versus Connecticut was a great example. The state of Connecticut had a law that said you couldn't, as a doctor, prescribe contraception, meaning birth control, to patients. And Dr. Griswold said, I think this is a bunch of malarkey, and I would like to challenge that law. So she couldn't actually challenge the law. She had to actually do it. I actually had to prescribe that contraception to my patients. She had to get arrested, and then she had to sue to get to a point where she could challenge that law. Okay, so that's the second thing. You have to have suffered real harm. Third thing has to involve a substantial federal question. So if somebody says like, hey, your dog's peeing on my roses and it's ruining them, I don't care if I have to take you to the Supreme Court, I'm gonna get my money back for my roses. They're lying to you. The Supreme Court doesn't really care about your roses. There's no substantial question there. Now, if your freedom of speech had been violated or your freedom of religion, there's a question that applies to lots and lots of people. That is a substantial federal question. The Supreme Court would be much more interested in that. The last thing is there are no political questions. Now, there are exceptions. I think I talked about the Bush versus Gore election 2000, how the Supreme Court eventually had to weigh in on that one. But generally speaking, if the legislative branch or the executive branch can solve it on their own, they like to stay out of their business. They don't want to get involved. So they don't like to answer political questions. Okay, that's kind of like the criteria for picking an actual case. Now, like I said right here, has to be the right case at the right time. There's been a couple instances, and I'm sure there's more than a couple instances in U.S. history where the Supreme Court has kind of stalked certain cases. Brown versus Board of Education is a great example. The court had kind of decided that school segregation probably needed to go. So they were looking for a case that they could actually take and rule on and end school segregation. There were a lot of cases that appealed to them. However, the Brown case had the right set of facts that they felt like they could make that happen. Okay, so sometimes they look for the right case at the right time. If they want to make a ruling on, I don't know, any kind of new law, the internet or whatever the case is, just the first one that comes along isn't always the one they're going to snag. They're going to look for, again, it's got the right set of circumstances so they can deliver the message they want to deliver. Once they pick the cases, so I said they use the rule of four of those 9 justices agree. Once they get that decision, now's the time to determine, do they need more information or can they give a ruling on this? Sometimes the issue, what's called a per curiam opinion, that actually is spelled right, by the way, which basically is, I don't need to hear from the lawyers. I don't need to hear arguments. We know how we're going to rule right now. So they can issue a very quick ruling. It's not signed by the justices. So they can pick it and say, by the way, this, and this needs to happen. See you later. Have a great day. If they don't do that, that's when they ask for more information from the lawyers, briefs or other legal documents. That's when those amicus curiae briefs sometimes come in that other parties decide maybe they want to be involved, give you some info, and then the justices can take that into account. And then eventually, like I said, those people will have their day in court to deliver their oral arguments. So that's how cases are selected among the Supreme Court. If you have any questions, please feel free to comment. I will see you guys around.